I think all parties are present, including 7 commissioners. Good morning. Today is May 5, 2021, and this is the hearing for the presentation of oral argument on the Christine Hollifield matter before the Michigan Unemployment Insurance Appeals Commission. Welcome, everyone. The 2 related cases are docket numbers 262-734W and 263-102W. I am Julie Petrick, the chairperson of this commission. The argument will be presented before the full 7-member commission, each one of whom is present by Zoom video conferencing. All of the commissioners are present by video except for Commissioner Morrison, who does not have video camera accessible to her. Under the executive order that created this commission as a replacement for the prior appellate body, the commission was authorized to designate issues as matters of first impression. The Hollifield matter is this commission's first impression case. As a matter of first impression, the case will be heard and decided by the full 7-member commission. The matter as designated by this commission is whether a part-time worker is eligible for pandemic unemployment assistance benefits. The parties provided excellent and informative briefs. The commission also received 5 amicus briefs. All the briefs have been posted to the commission's websites, and we thank you all for your excellent scholarship and advocacy. I understand that this case has wide-ranging interest in Michigan based on the impact of this decision on part-time workers in this state. Because of that interest, it is my expectation that the video of this hearing may be widely viewed. Because of that, I take a brief moment to explain the review authority of this commission as an appellate body. This commission is an appellate body that reviews decisions of administrative law judges. It bases its decisions solely on the facts and an application of the law. Present here are the attorneys for the parties, Christine Hollifield and the Unemployment Insurance Agency. The organizations that submitted the amicus briefs have also been given access to the Zoom credentials and may be present as well. We ask that all non-parties keep your video and mics off so as to avoid any distractions. As to the order of proceedings, each party has 20 minutes for his or her presentation, and time may be reserved for rebuttal. A question and answer session will follow each attorney's presentation, and then we will conclude with rebuttal reserved by the parties. And with that, we will start with the attorney for claimant appellate, Christine Hollifield, David Blanchard.
Hi, good morning, Commissioner Petrick. Good morning to all of the commissioners and the others joining us this morning. Thank you for your time and attention to this matter, to the briefing that's been submitted, both by myself, by the agency, and by the amicus parties. I appreciate your attention and designation of this matter as a matter of first impression. I would like to start by reserving 10 minutes of time for rebuttal in this matter. And I would also like to start by noting that although there were several opening briefs by the claimant in this matter, the comprehensive opening brief is that filed on April 12th, written argument by the claimant, Christine Hollifield. And so we refer to that one and the exhibits attached as the comprehensive opening brief. With that, I will get started. Start the shot clock. And I just wanted to review briefly. I'm not going to try to rehash the every argument or every citation in the briefs that have been submitted. As Commissioner Petrick noted, it was a matter that has been thoroughly briefed and really a matter that can be decided as a matter of law. It does involve the complicated interaction of state and federal law and new and unprecedented federal law under the CARES Act and the pandemic unemployment assistance that was granted as part of that act. But the clarification and interpretation task should not be so hard. There is one interpretation that harmonizes federal and state law, provides for uniform administration of federal disaster assistance across the states, and avoids discrimination against disabled workers in Michigan. And there is another interpretation reflected in the early agency briefing that able and available determinations require a full-time job seeking and that's reflected in the ALJ opinions on appeal, and it would put the state and the federal law in direct conflict and frustrate the purposes of the CARES Act, would lead to a clawback of federal disaster relief for part-time workers in Michigan, and would violate the state constitution and federal disability discrimination law. Fortunately, the state's most recent briefing, the agency's most recent briefing, I should say, from April 26th, reflects that the agency now agrees with the harmonizing interpretation. So the choice should not be a hard one for the commissioners here, but is one you have to make because guidance is desperately needed by the administrative law judges who make the opinions for everyday Michiganders seeking jobless benefits during a pandemic. The Pandemic Unemployment Assistance Program and the Disaster Unemployment Assistance Program that it was based on do not require individuals to work full-time to be available and able to work full-time. Nowhere does that reference occur anywhere in either the PUA or the DUA. The Department of Labor's Unemployment Insurance Program Letter 16-20, Change 1, at page 2, notes very clearly exactly how states should go about applying pandemic unemployment assistance. First, the state is to look to the CARES Act and the provisions in 2102 of the CARES Act, then to the guidance from the Department of Labor contained in the UIPL's Unemployment Insurance Program letters, then to the Disaster Unemployment Assistance Program, Section 625, and then to state law. Taking those in order, it is clear that an interpretation reflected in the determinations on appeal that requires full-time work is not warranted, first, under a plain interpretation of state law, and second, that if it were, it would put the state's interpretation at conflict with the purpose and intent and goals of the CARES Act and the Federal Disaster Unemployment Assistance Program. Under PUA and DUA, the UIPLs have noted that claimants may be eligible for any week in which they could work a portion of that week. Michigan law does not define able and available to mean full-time, as noted very skillfully by some of the amicus briefs that have, and amicus curiae parties that have joined in the briefing on this matter. Michigan law further does not define full-time. And so there is a great vagueness, a great lack of clarity that puts Michigan unemployed workers at a disadvantage when seeking benefits. The agency determinations issued to claimant would require PUA claimants, PUA claimants, to be able and available and to work full-time. It is not reasonable. It's not a reasonable interpretation of state law, nor is it one that harmonizes with the federal enabling legislation or the guidance from the UIPLs. The state would seemingly now agree, referring again to the April 26th reply brief of the state, which we've quoted and discussed in claimant's most recent reply. Agency determinations requiring full-time job seeking would violate the Michigan Constitution, the Equal Protection Clause in particular, and the Americans with Disabilities Act. Thankfully, there is no need to go there. Thankfully, the state would agree, the agency would agree, that those that qualify under the enumerated provisions of the Pandemic Unemployment Assistance Program would qualify for the benefits there without application to the full-time work standard applied by the determinations that are on appeal. So the lone issue that's remaining, as I review the briefs, is whether claimant falls into an enumerated category of the Pandemic Unemployment Assistance covered individual as defined in the CARES Act. The administrative law judge below has already conclusively decided that. It was not appealed and has never been subject to any agency determination as the able and available determinations on appeal were. It was not noticed as an issue before the commission. What it means for a self-employed individual to have their place of business closed is an interesting question, but not one that's presented on the record here, not one that's conclusively briefed, and not one that I would invite the commission to entertain at this time. The sole issue on appeal is whether the state agency can impute a full-time requirement into its able and available standard for PUA recipients in particular. This tribunal should and must rule in claimant's favor and reverse the ALJ decisions and the determinations below. The agency stated in its most recent reply brief, those whose workplaces were closed as a direct result of COVID-19 public health emergency are exempt from the ability and availability requirements. Thus, those impacted by the COVID-19 pandemic are exempt from the state law requirements at issue. Claimant agrees. We don't fault the agency for taking sometimes conflicting positions, for grappling with a complicated legal issue that has changed and the interpretation has evolved over time. But we invite the opportunity here to get to a uniform standard for Michigan's unemployed receiving pandemic unemployment assistance. A uniform standard that Michigan residents and part-time individuals can understand and apply themselves when they ask, I've lost my job, am I eligible for unemployment assistance? Thank you again for your time this morning. And with that, I will reserve the remainder for rebuttal.
All right, we'll just go around and make sure everyone's cameras are back up again. I'm sending you a request to turn on your camera, commissioners. Let's get everyone back in the visual realm here. Okay. And Commissioner Morrison did not have a camera this morning, so I think we are all set, Commissioner Petrick, Chair Petrick.
Yeah, I would like to start off with a question, and then I'll just go through the various commissioners and ask them if they have a question. And I would like to start off with the ALJ decision that finding that the claimant in this case, in fact, fell into one of the enumerated COVID related categories, and that her work was stopped basically because the auction houses was closed. I note that she did not set forth a particular provision AA through KK as to which category that she fell into. So I have a couple of questions related to that. Number one, is it your position that we are bound by that decision that she falls within one of those enumerated category? And the second question is, I do note that in 1620, the document 1620, the first one, April 5, 2020, under KK, the Secretary of Labor is entitled to add additional criteria. And at I-6, there is an additional criteria related to independent contractors with reportable incomes whose ability to continue performing his or her customary work activities has been impacted by the COVID. And I wonder what your position is in relation to whether her circumstances fall within this category.
I do believe her circumstances fall within that category. They would also fall within the category of the inability to reach a place of business due to COVID, and also the category that the administrative law judge noted below, the place of business is closed due to a pandemic. So all three of those categories would apply. We do believe that based on the unrebutted testimony below and the fact finding below at the ALJ, that finding is conclusive at this point. If there was further fact finding that needed to be done, it could be sent back if and when there was an agency determination that she did not qualify under one of those categories. But there has never been such a determination. And so that would be kind of a reboot and a restart. And we don't think that that's appropriate for the commission to address at this time. That finding from the ALJ should remain undisturbed. And, you know, as you noted, the Department of Labor has added a category. In part, I think the Department of Labor, that was after the fact finding that occurred below. So again, we should be bound by what happened below, or if we're going to restart and do further fact finding, we could do that on that point. But I do think, like I noted before, that this is a very interesting and difficult question that we're grappling with if that's raised. Because what does it mean for a self-employed individual to lose their employment? And what does it mean for their place of employment to be closed? For many people, they're self-employed, they're plumbers, they're carpenters, there are others that can't go to a job site where they might have a customer that I've represented people that go into home, you know, they're cabinet makers, and they would go into a home and get a job and do that. They weren't able to do that during the pandemic. On the other hand, there are people that if you're a self-employed individual, you certainly can't just write yourself a letter and say, I'm laying myself off right now and it's due to COVID. The relationship and the job relationship is different when you're talking about self-employed individuals. And it's an interesting question that we're not grappling with today, but we may have to grapple with in the future.
So in terms of the response about the binding nature of it, since this is the claimant's appeal, what would your position be about whether the agency could have an alternative grounds for affirmance of the ALJ decision?
Well, in my experience, the way the administrative system works is if there is a grounds for denying benefits, then what's first required is a determination that's issued by the agency. And there's a process for that, and there's a protest, and there's a redetermination, and then there's fact-finding that occurs at the ALJ level. There's been no determination, as I noted here. I would also note that the DOL guidance is quite clear what is required of an individual for pandemic unemployment assistance is for that individual to self-certify that they qualify under one of those categories. That guidance is quite clear from the Department of Labor. There is no further requirement or fact-finding needed. What would be needed is the question of whether the person self-certified or not.
Thank you.
And the only fact-finding, I guess, would be whether that was truthful or not truthful in that certification.
Okay, then that satisfies my questions. I'll move on to Commissioner Del Pino.
It's Del Pino, but that's okay.
Del Pino, sorry.
I have no questions at this time. Thank you.
And then we go to Commissioner Morrison.
Let me unmute. I don't have any questions at this time.
Commissioner Wacharski. I'm hearing, giving him another second.
Please repeat the question. He was momentarily muted.
No questions for me.
Okay. Commissioner Rossi.
No questions, thank you.
Commissioner Runco.
I'll break the trend here, ask a question. Mr. Blanchard, thank you for the work you've done on this, first off and foremost, and for your work on behalf of unemployed workers. So as I read Judge Wilson, I'd like to reference Judge Wilson's second decision or opinion on page 4. Under findings of fact, she says, as a result, this is the second sentence, as a result of the COVID-19 pandemic, the claimant's place of employment shut down operations and claimant lost her part-time employment. And so then I think if I'm understanding your argument, I guess I just want to understand your argument correctly. So if that's the case, I guess what you're telling us, this is a pretty simple matter, because under the CARES Act, double J, it says that the person's otherwise able and available, has to be otherwise able and available under state law unless the individual's place of business is closed as a direct result of COVID. So I guess what you're telling us is a pretty simple case, then, right? We just simply apply double J to the fact finding and we're done. Is that overly simplistic? Am I on track with what you're suggesting?
I think that's absolutely right. I think there was earlier in this case a question of full-time availability being required of individuals, even if they qualify under one of those categories. I don't think there's any disagreement at this time that it is not a requirement for those qualifying under those categories.
But what exactly was her place of business, place of employment?
Well, again, the self-employed nature of her work creates a different kind of an analysis, a different kind of interpretation of a place of business. Her gainful employment, the way she worked, was to go to auction houses selling basically excess construction goods and be a buyer. She was essentially a buyer at an auction house. She would go, she would inspect the product, she would make sure it's good, it's a good deal, and bid on those products, and then deliver those to her customers that are in the construction trades. That entire system shut down at the start of the pandemic. Both the auction houses that she would go to do the work, and we're saying that is her place of employment, and the construction trades people that she would service who weren't doing construction at that time, weren't primarily in this line of work. It's not on the record, but if we want to talk about it, it was about rehabbing apartments. And so her customers would buy excess goods, whether they're toilets, refrigerators, linoleum flooring, etc. And her job would be to find those goods, make sure they inspect them in person, and participate in an auction. And those were certainly closed. They're places of public gathering in which people were, if you've ever been to an auction, you understand how that works.
Yeah.
And are shouting and are bidding on goods and inspecting those. She was not able to do that. And so we would say for the interpretation here that her place of business was the auction house. For a self-employed individual, again, this is an issue that is of first impression, but not noticed here. What does it mean, a place of business for a self-employed individual? She also worked out of her house. What does that mean for a place of business to be closed?
So that's kind of what I'm curious about, because I noticed the Attorney General makes the argument essentially, and we'll hear from Ms. Smith on this, and I don't want to misstate what she said, but I believe she says something to the effect that just because the auction house is closed doesn't mean she had to stop her self-employment. There's other things she could have done. Do you care to respond to that?
I mean, I just don't think that makes sense with the economic realities of the situation. If you're a plumber and you're unable to go into houses and do that work, your place of business is closed and you're not able to do the work. If you're a carpenter, the same. If you're working auction houses, the same. It's not realistic, and again would be a very restrictive and damaging interpretation to adopt such an interpretation.
And I can appreciate that. I guess in summary, I'm just concerned about this whole concept of what is meant by a direct result of COVID, and I think that's what the Attorney General is getting at. And I guess it is an interesting question. I understand the fact that the auction house is closed and that caused her to lose that particular line of business. Would there have been any other line of business that she could have done in terms of what she does? I guess is the question that is not contained in this record, but maybe it should have been. And, maybe we need to know that, maybe we don't. But I just want to get your take on the AG's position relative to alternative types of businesses she could have performed.
Again, thank you for the question. Again, I believe if the agency took such a restrictive interpretation, you could essentially say that anybody that's self-employed could just, if they were seeking other lines of work, then they wouldn't be unemployed and wouldn't qualify. But that's just not the reality of the situation for many self-employed workers. They have a line of business, they have customers and prospective customers, and when that evaporates as a direct result of COVID, they should qualify for benefits under the CARES Act. It would be a damaging and restrictive interpretation to go further than that. But I do not believe that issue
I think we should
there hasn't been further fact-finding or evidentiary finding.
Mr. Blanchard, if you could please repeat the last paragraph or maybe a couple of sentences. Your feed kind of froze up a little bit. I want to make sure we're hearing all the comments.
Well, I'm not sure where I froze up, but I was saying it would be a very damaging interpretation that would deny Michigan residents pandemic unemployment assistance again. Did that come through?
Yes, we got that. Thank you.
Yeah, just one last, when I sat as a district judge, people would always say, one more, just 5 minutes and be 25 minutes. And this will be the last question, but how would you define the word direct in the context of this statute and in the context of, double J? So, because I think that's the real key here is the direct result. So tell us how you would define that word direct. In this case, somebody could argue it's indirect because the auction house is closed and then she had to close. How would you define it?
I think when an individual loses their gainful employment because they're unable to do it due to one of the COVID enumerated reasons, that is a direct result.
All right, well, thank you.
All right, we move on to Commissioner Young, please.
Morning, Mr. Blanchard. Right to where I'm at, if we were to rule that the claimant is otherwise able and available to work within the meaning of the applicable state law, right? That's the PUA requirement. If we were to find that in this case, what is the consequence of such a holding on state law outside of the PUA? Going forward, I mean, we're moving in 2 years down the road, right? Does what we decide in this case today have any consequences on state law?
I think
28(1)C specifically.
Mm-hmm. I think it need not. Section 28 and 28(1)C contain a variety of requirements. Section 28 is not and does not claim to be a definition of able and available. Section 28 is an eligibility criteria. And within that, there's discussion of what's of able and available, and there's discussion of job share, and there's discussion of return to work and instances and when there can be a waiver. It is an eligibility criteria. So that section overall should not be affected and would not change based on the ruling here. The ruling here is just whether the full-time requirement that's in there is actually part of a definition of able and available, and if it is, whether it can be applied consistent with the purpose of the CARES Act. We say
so you see this then as a very limited, very specific, very narrow question, right? I mean, as I would see at this point, correct?
Well, it's a broad and important question for those receiving benefits.
No question about that. But the actual, what we decide here is a very, in a sense, we're taking some, we're moving it. We got 5 P's and we got 2 P's in this pile and 2 P's in this pile. And the question is, where's that middle P go? We put it over here, we put it over here, right? I mean, that's kind of the one, it's either going to go over in the able and available pile, full-time as part of able and available, or it's going to go into the eligibility pile. Full-time as part of eligibility. In either event, you still have to be eligible for benefits and employment, so you still have to have full-time. And is there anything we're going to do here today that's going to upset that apple cart down the road? Am I going to see this case coming back to me, with Runco's name all over it and saying, hey, you said in this case, and I'm going to quote, right, Reverend Commissioner Runco, and then it's all going to come coming back at us? Or are we really kind of agreeing, I think at this point, not that this is a very, very narrow, very specific, very limited holding in this case because of PUA?
I think it is limited to PUA. Either way you put that, either place you put that P, as you say. If the full-time requirement falls under eligibility, as we believe it should, there is no conflict in the application of the PUA standard, and no impact on eligibility generally under the Act, as how it would be applied to non-PUA regular benefits. If you put it in that P in the other pile and find that as a matter of law, Michigan's definition, which is wildly outside the norm, is a minority of the states applying an able and available standard. But if you found that full-time requirement is part of the definition of what it means to be able, which we believe is wrong, then you would have to reach the following conclusion that could not be applied consistent with the CARES Act. And so there would be a conflict there where it wouldn't be applied in that instance, but again, would not invalidate the law generally as it applied to regular benefits.
Okay, thank you. Appreciate that.
Do any of the commissioners have any follow-up questions after we've gone through the whole cycle? And seeing none, I think that we can then start with Attorney General Rebecca Smith then presentation.
Thank you. Thank you again.
Thank you, Mr. Blanchard.
Okay, we will bring her video feed up.
Morning,
And
commissioners.
Let me
Morning.
get you spotlighted here, Ms. Smith. And we'll
Okay.
begin to shut everyone else's video off. Okay, we are good to go.
Good morning. So I'm here to speak on behalf of the Unemployment Agency. I'm Assistant Attorney General Rebecca Smith, and I want to start by saying that there are lots of ideas and policy arguments floating around in this case about who should be eligible for unemployment benefits. And I want to start by saying the Unemployment Agency does not disagree with these policies, and it is open to granting unemployment benefits to part-time workers, and in fact pays PUA benefits to part-time workers, but it can only grant those benefits within the confines of existing state and federal law. And under the facts of this case, that law just simply does not extend benefits to Ms. Hollifield. Under the terms of the CARES Act, a covered individual must meet two basic criteria. They must not be eligible for traditional unemployment benefits. And I think everybody's in agreement that Ms. Hollifield would meet that criteria. But they must also certify that they are either otherwise able and available to work under state law, which Michigan law requires full-time ability and availability, unless they're off work for one of these COVID-19 circumstances. And I think the very limited factual record in this case does not put Ms. Hollifield in one of those COVID-19 circumstances. It appears that the ALJ believed it, and Ms. Hollifield seems to indicate that her place of employment was closed as a direct result of COVID-19, which would put her in subsection JJ. But the record doesn't really support that. The limited facts we have are that Ms. Hollifield was a self-employed delivery driver, that she did some work for auction houses, and that the auction houses were closed as a result of COVID-19. Ms. Hollifield's testimony was not clear that she actually worked at the auction houses. It sounded like she worked more out on the road. And she was not actually an employee of those auction houses. Her testimony was that she was self-employed. We also don't have any testimony from anyone at the auction house establishing whether it was entirely shut down. They could have, been doing auctions online or things of that nature, why it was shut down and how specifically that related to COVID-19, whether it was under government orders or just because business had dried up. We don't have that evidence and those facts on the record. Without those facts, the CARES Act is unambiguous that she would have to be able and available to work under state law, and Section 28(1)(c) of the MES Act is unambiguous that in Michigan that requires full-time ability and availability. Hollifield has been consistent throughout this case that she cannot work full-time, and so she does not meet that criteria. And because she can't place herself based on the evidence in one of those COVID-19 circumstances, and is adamant that she can't meet the state law full-time requirements, she simply would not be eligible for benefits in this case. Everybody has talked about how the statute doesn't define full-time, but I think, because it's undefined, you can default to kind of an ordinary understanding of that term. And in most contexts, full-time means 40 hours or right around there. And Ms. Hollifield, the unrebutted testimony we have is that she can't meet a full-time requirement, however it's defined. Everybody talks about also, Ms. Hollifield, the conflict between the PUA ability to pay benefits to part-time workers and state law, but such a conflict only exists where it's either impossible to comply with both statutes or the state law is an obstacle to basically performing the overall intent Congress intended with the legislation, and we don't have either of those circumstances present in this case. It's not impossible to lose a part-time job and still make yourself able and available for full-time work if it's offered to you. And so the impossibility criteria doesn't apply. And in terms of that second impossibility issue with interfering with the federal intent, even under UIA's interpretation, PUA in the CARES Act has dramatically opened unemployment benefits to self-employed workers, 1099 workers, those without sufficient wage history, and part-time workers who either meet those COVID-19 requirements or can conceivably make themselves available full-time as required by state law. There's nothing with the agency's interpretation that would interfere with the intent of the PUA program. And in fact, the PUA program has expanded access for lots of people, particularly those directly affected by COVID-19 as detailed in those COVID-19 circumstances. And so there's no interference with the overall purpose of the act. To the extent everyone disagrees with the full-time requirement in state law, that's really a question for the legislature. The agency is bound by that, and PUA specifically incorporates that state law provision. And so in the absence of those COVID-19 circumstances, that's the law we have to follow, and that does require full-time. I wanted to briefly address, just a couple of the issues that the commission had asked about. The commission had asked about whether, to consider the ADA. We had stated in our brief, and there was case law to support this, that the ability to file an unemployment claim is not a protected ADA activity. And I think, nothing really prohibits disabled workers from filing claims. They have accommodation and access just as any other worker would. This commission also asked specifically about the disaster unemployment regulation and the exceptions to the state law working requirement in DUA benefits are specifically different than those enumerated in the CARES Act. And so those DUA regulations would not apply. The exceptions to that state law requirement that we're looking at in this context are those COVID-19 circumstances enumerated, in Section 2102 of the CARES Act. And as we said, it's our belief that the limited factual record in this case simply does not put Ms. Hollifield firmly in one of those categories. While the agency did not file a separate appeal on that, as the ALJ came to kind of the overall correct application in Ms. Hollifield's case, this commission does have a de novo review. It can change or modify decisions and even take new evidence. So this commission certainly can consider that in the scope of today's proceedings. I'm trying to think. I think that's our overall position, and I think there's been a lot of rhetoric about the agency's policy and position, and I just wanted to make it clear that we're not saying part-time workers can't be eligible for PUA. They just have to either meet the state law ability and availability requirements or fall into one of those COVID-19 criteria. And Ms. Hollifield, based on the factual record we have regarding this particular claimant, can't establish those things.
And I'm assuming that concludes your presentation, Ms. Smith, is that correct?
It does. I think that covers all our ground. I think, to the extent there's other issues, we did cover that in our briefing, and I'm happy to answer any specific questions the commissioners have about our position.
Okay, thank you. I'll begin to bring up the commissioner's video screens here.
Thank you, Attorney. Let's see, start my video. Okay. Thank you, Attorney General Smith, for your presentation. We really appreciate that. I'm going to go to the same question that I asked Attorney Blanchard, which is in relation to the additional criteria set forth by the Secretary as authorized to do under KK and set forth in UIPL 1620 at I-6, where he indicates that an individual who works as an independent contractor with reportable income may also qualify for PU benefits if his ability to perform his or her customary work activities are impacted by COVID-19. So 2 questions in relation to that. This came out in April 2020. I'm not certain about, I think that the claimant in this case filed near the end of April 2020, and her claim was backdated to March 22nd, 2020. I am wondering if during any of her period of time that she was reporting, would she have had the ability to report as to the independent contractor prong of it, and whether it's your position that she would fit into that category?
I do not have, the exact timeline or Marvin certification questions she would have been asked regarding that, or whether she would have been able to certify for that. So I'm unable to answer that specifically based on the information I have about the case. To the extent that provision was in effect during the period of her case, I think, maybe she could establish those facts, but we simply don't have those facts on this record. The record we have about Ms. Hollifield's work in this case is that she did deliveries for an auction house, and the auction house was closed. We don't know if that's the only customary work she could perform, whether the auction house was completely shut down, whether, every auction she worked for was shut down. We just don't have enough facts on this record to say whether she meets any of the COVID-19 criteria. It's possible she might, but we don't have those facts on the record that we have.
Okay, thank you. Then I will move on to Commissioner Morrison. Any questions?
Okay. I'm going to defer. I do have a question, but I'm going to defer to Commissioner Young because we had discussed that question that I have.
Commissioner Orcharski?
You mentioned in your presentation regarding 281C that the MES Act does not define full-time work. What is the test for full-time work?
Well, I think as it's been applied, it varies some by industry to industry, and there might be some variation based on how a particular employer might define it. But I think the default would be how that term is ordinarily defined. And in ordinary context and dictionary definitions, that means being, available 40 hours a week. And so I think that would be the default. However it's defined, Ms. Hollifield's position has been that she can only work part-time. So however it's defined, Ms. Hollifield's position has been that she can't meet it.
Well, case law does define the criteria. And in Bowles versus ESC, the Supreme Court stated that the test is attachment to the labor market. Now, claimant has a history of working and earning wages. And since that term is not defined by the statute, then isn't that sufficient to put her under PUA, that she is attached to the labor market?
Well, in determining what is sufficient attachment to the labor market to meet the ability and availability requirement, and I would agree that that's kind of the end goal of the ability and availability provision, the legislature has defined that attachment as requiring full-time. And we're bound by that language. If the legislature amends Section 28(1)C to remove that, we might be talking a different circumstance, but the legislature in the MES Act has defined that as that attachment to the labor market as full-time.
Well, the Social Security Act defines full-time as 23 hours a week. Okay. And some of the other acts define it as 30 hours a week. And then others define it as 40 hours a week. And claimant was collecting Social Security. So why isn't she covered under the 23 hours?
I think in the unemployment context, it's most commonly defined by how that industry or employer considers full-time. And so I think that would be what we're looking at. And we don't have testimony in the record as to what Ms. Hollifield's industry or how she would define it in her particular line of work, or how it's defined generally in terms of deliveries or auction houses. And so I think that would be the criteria that we're looking at. And so I think the default would be, a 40-hour work week. We're not talking about Social Security benefits, so I don't think that 30-hour definition would be binding. I think, we simply don't have that information, so we'd have to default to, what a normal understanding of a full-time requirement would be. And I think in this case, irregardless of whatever that circumstance might be, we don't really have the facts, but Ms. Hollifield's position has been she cannot work full-time. So however it's defined, her position has been she can't meet that requirement.
Yeah, but you're assuming that what that claimant knew what full-time work is. Okay. Now, she was limited because she was collecting Social Security disability. Okay. And most of the claimants that appear before the agency are not represented. So they're not aware of the intricacies of the act. And so her testimony, just because she said, I'm only available for part-time work, does not mean that she's only available for part-time work, because she's limited by the Social Security Act, and unemployment is covered by the Social Security Act. It's not covered by any other separate act. It's covered by the Social Security Act.
It is, but I don't think the Social Security Act language you're talking about is specific to unemployment benefits. And, Michigan has adopted that full-time, and it's not clear that, in that full-time language in 28 that they intended 30 hours specifically drawn out of the Social Security Act. So I do think we need to look at what's customary for that employer or that type of work. And I do think most claimants, even though they may not be aware of the underlying legal cases, do have some concept of whether they're a full-time employee or a part-time employee. And Ms. Hollifield's understanding of that in her industry is that she cannot work full-time. The statute requires full-time, and so we're stuck with that circumstance where she acknowledges she can't meet the state law requirement.
Thank you.
Okay, we'll move on to Commissioner Young.
Unmute. Oh, I'm on mute. Hey, way to go, Ken. Thank you. Assistant Attorney General Smith, I do want to congratulate you, I guess, too, on what I thought was a well-written and well-reasoned brief. And the reason I'm commenting on that, I did on Mr. Blanchard, that was not to take away from Mr. Blanchard's brief, but kind of like Mr. Osharsky, Commissioner Osharsky, I've been in unemployment for, well, he's been more than I have even, but over 30 years. And when faced with the question, I remember when Commissioner Runco called me about this case, he called me on the phone and I had nothing better to do on a Friday night. He got all excited. Neil, there's this case and he wants to talk about it. Blah, blah, blah. And I go, Bill, I mean, come on, disability. Yeah, there's some cases out there that say you can still get benefits if you're getting disability insurance, but how does she survive, able and available, for suitable full-time work, right? It just flows right out of my mouth, right? Able and available for suitable full-time work. It's kind of the shorthand. It's what we all know. And so, I'm looking at that. And when I saw your brief, I go, yeah, this was the argument that I like to think I would have made in many of the things that you raised. And but I also concur with Mr. Blanchard's observation that we're in a kind of a unique time in that, we're all working through this as well. And to include what you were doing in your brief. And as I was reading it and going through it all, I've just, raised a couple of different questions. So I guess I want to come from the standpoint of that. I'm not attacking on this at all, but I'm looking at the idea that says, hey, if we go down this and we look at it slightly from a different direction, do we get a different result, but without a problem with the legislature? So I just want to kind of give you that heads up. Okay. So the first question on this would be, and let's setting aside the question of what, whether it's JJ or DD or wherever the claimant, let's just assume that the only issue that we have to deal with, the only issue that I'm concerned at this point is the issue of the full-time. All right. So when I ask about that, we're going to have to do a caveat of otherwise eligible, right? We're going to assume that the only issue before us right now is that full-time question. So my first question would be that if 281C did not contain those references to full-time, would there be any problem with claimants who are disabled and are not able to work full time? Again, whatever that issue. And I agree with you at this point, we don't know. It's not being alleged. That's not what we're here to decide right now. We're going to assume that it is part-time work that they're available for, right? Whatever that's defined as. Is there any reason then that a claimant shouldn't be able to get benefits under the PUA?
Assuming, if Michigan's law did not require full-time and a claimant is saying I can meet the state law requirement, disabled or not, they would be eligible. We're not saying disabled people should be, excluded.
Okay. No, all right. That's cool. All right. And that'll get us to the thing. And that's part of that. It's even funny. Okay. Good part on that. And again, this isn't like, I'm not setting you up for some great aha. It's not a game of Clue, right? Okay.
UIA's position
Sure.
is they're boxed in by that full-time language in this case. You have a claimant saying they can't work full-time. We're required to comply full-time.
And we recognize that, you said, the Michigan legislature, that full-time language is not, every state does not have full-time requirement. Michigan,
Yes.
There is the words full-time are there. Now, as I alluded to earlier, I kind of look at this as I'm divvying up the P's, right? I got my P pile over here that says able and available. I've got my other pile that says eligibility, right? The 28.1 is eligibility. 28.1C includes able and available. And the question is, does that full-time P belong there, or does it go in a sense overall? So just getting a context here. When I looked at the brief, the one thing they did strike out was there's a couple of different times in both the brief and the reply brief that you said Michigan's full-time ability and availability provision. And again, I'm not like, this isn't coming at you, right? Because this is the type of thing that I would have done 100 times in normal world, because in strictly under 28.1C, and we've had some discussions with ourselves. That's why I'm bringing it to your attention here. But you'd say, well, able is one thing, available is another thing, and then there's full time. And if you didn't meet any of those threes, any one of those is dispositive. If you weren't able, you're done. If you weren't available, you're done. If you weren't for full time, you were done. Because you sometimes never get to the question of full time. The person just wasn't able, right? Dwyer is available in Dwyer case, right? Supreme Court. Dwyer, they full time wasn't the issue. The issue was availability. So you don't have to always get to, what I'm saying, but at the same time, we shorthand this off, able and available full-time work. It's just a common thing that we're saying. So when you're right, Michigan's full-time ability and availability provision. And it got me thinking when I read that, I said, wow, is that really what the provision is? And so I'm looking at it and I think, is that an accurate statement? Right. And again, if the wording of the act would have the order being differently, able, and then suitable full-time, and then later on available, the full-time's added after. But then my other follow-up on that is it a necessary statement, right? And I understand, again, the perspective that I would have come at this from is exactly the perspective that you're at it from, right? I get that, not disputing that. But when I look at that, I think so now it gets to the next part of this, my little setup on this. So if we look at this, and I think again, with this idea of the full-time availability provision, what if we instead looked at this with Michigan's full-time eligibility requirement? And I know I'm not trying to rewrite the statute in a sense of like, okay, we can just move some words around, it'll be great. But at the same point, like I said, because able, available, full-time, they're all issues, they're separate. We look at them together, but they do come separate. They're separate language. 28.1 is to be eligible, the agency must find all the following, right? And, clearly, I mean, the requirement full-time is a requirement for eligibility. I think that's what the Attorney General Nessel argues in her brief. I think that's a little bit what Mr. Blanchard was talking about today. The real question is the full-time, is it a necessary requirement for able and available? And so I look at that, and before I have you answer that question, when you look at the case law from other states that deal with able and available, they don't have to address full-time when they decide able and available. It could be a component, maybe, as they're looking at the attachment. But Dwyer, our Supreme Court case, says, and again, I'll admit that they said, well, the full-time work, they threw that in there because, again, the assumption, but it wasn't necessary. It's never been necessary. I'm sorry, I'm pontificating here. I'm sorry, I don't want to go. But I think this is the crux of the matter. In Michigan law, I have never been aware where it has ever been necessary that we parse out the full-time requirement, in a sense, almost the Trinity, right? Able, available, full-time. It's never really mattered that you could be able and available, because if the full-time wasn't there, you're not going to be eligible. Eligibility 28.1. So here, PUA is saying, look, we're asking you to be able and available under state law. Okay. So if we can go to able and we go to available, and then we get to we in Michigan will always go to full-time next. We have to, because it's eligibility. But able and available is a part of eligibility. I'm telling you things here, right? I'm trying to get you to where I'm going. I'm sorry, everybody, you can all tune out. They do anyway. They never listen to me. But on this particular part, I guess what I'm thinking about this is how we look at it. Is it necessary that we tack in full-time to able and available? I understand the necessity of it for the eligibility question. But for us to sit there and say, I can look, as Dwyer says, that the issue of availability is a subjective test, right? It's subjective. You look at all these different things, subjective. Full-time, part-time, even though we can debate that, but we're kind of doing that today, is that a subjective question, or is it really ultimately an objective question that we say, based on these facts, we find this to be, in this case, to be full-time, right? It's kind of and we may even come down to a test one day, or there is a rule. But I'm saying in this case, can we say, because all PUA is asking for are they able and available? And if we look at this test and we say, hey, wait a minute, is it really Michigan's full-time ability and availability provision? Or is it just that? Because if you count through 28.1c, I think I counted like there's 9 different components of 28.1c, of which you could argue able is one. And again, I'll always say able and available like they're one. Well, able is one, available is the other. You can't be eligible without both of them. But it still is 1 and then 2. And I counted, I think, 9 to include the full-time, to include civil work, all the different ones. So each one of those is a component of what? Ultimately being eligible. So I know I'm throwing this at you and trying to get you to go where I want to go with this. But the real question is does this have to be a requirement? And then the second question is this. All right, kind of going to ask you the same thing that I asked Mr. Blanchard, right? I said, if we go ahead and we rule this way, if we sit there to find that we can be able and available, just looking at those 2 provisions, able and available, we don't have to go to full time, because that's not what PUA is asking us for, right? And we say we apply Dwyer, we use our subjective test, we can say all the case law we've had about those other things about able and available without adjusting full time, and we can apply that case law. If we were to do that, and we realize that full time, we're not reading full time out of the statute. For eligibility, full time still exists under 28.1c. What is the consequence of us doing that in this case? What is the negative consequence? Is there a consequence down the road in the state law? Is there a reason that we have to do this? Because clearly the Fed isn't saying that you have the full-time requirement. They could have written it in. They didn't, right? They left it to us. So I get that. But I'm saying is, can we do able, available, and then stop without upsetting full-time? It's still in the order there. It's still in 28.1c for when we get back to a normal state case. So I know it wasn't really a question. You can object. Okay. But I wanted to give you the idea of where I was going, and I wasn't trying to surprise you. So do you have any questions on my question before I go there?
I think I understand the groundwork, and I think I have an idea how I want to address it, but I'll let you get your actual
Sure. No, I'm good. Yeah.
question out.
Well, that's pretty much it on this, is that the idea that says one is, can you do able and available and stop? Is full-time is a necessary element of able and available, considering the fact that other states do able and available without full-time. I mean, it's not the subjective test doesn't say that requires a consideration of that full-time requirement. It's just an addition that we have. And then the second thing is, if we did this, if we rule in favor of the claimant here and find that they are able and available within the meaning of the applicable state law, is there a negative consequence, unintended consequence that we're not aware of by doing this?
Yeah.
That you're concerned about?
I am concerned about consequences, and what I'm concerned about is you look at the able and available provisions and then go down and look at the full-time provision addresses full-time in the context of ability and availability. 28(1)(c) specifically says claimants must be, quote, able to appear and to perform full-time work for which the individual is available full-time. In Michigan law, you cannot divorce that full-time language from the ability and availability just because of how the statute is worded. And so when the PUA incorporates state law ability and availability, it carries over that language in Michigan. Now, I'll acknowledge that not all states have that full-time requirement. Many don't. And so, PUA may apply differently, but in PUA's incorporation of state law without qualifiers, the way it incorporates the state law ability and availability provisions, it would by necessity incorporate Michigan's full-time language. So if the state law applies to PUA because one of those COVID-19 circumstances doesn't apply, that full-time requirement would apply. And I think the consequence of ignoring that full-time language and, limiting it to just ability and availability without considering that full-time language would have consequences, because PUA and regular benefits, because of that PUA's incorporation of state law, essentially apply the same ability and availability law. And I could see claimants after this crisis taking those PUA cases and saying, look, PUA incorporated state law. They held, that doesn't require full time, and saying that state law language no longer applies. I think PUA did incorporate the full state law ability and availability requirements, which under the very terms of the statute do require full-time ability and availability. And so in applying PUA, we're stuck with that language. And to the extent we don't follow it, it could very well have consequences, because PUA and those state provisions apply essentially the same law.
I'll do two brief questions here, and then we'll get going, because I'm sure there'll be some rebuttal. The one question would be then, for us as a body, if we were to sit and say, okay, look, that we've looked at this, we've considered it, and we said that we think that we can, in a sense, section this off, able, available, suitable, full-time, location of prior service, et cetera, all those 9 points, right? And we say, look, able and available, and there is case law that discusses just able and available. So the state law requirement, there is state law that interprets able, state law that interprets available, without even dealing with the full-time. So if we were to do that and say that we find the claimant able and available under state law for purposes of PUA, do you think the Fed would then come after us and say, wait a minute, you misapplied your own law? Is that a concern? I mean, because in another state that doesn't have a full-time requirement, they're saying, yeah, fine, no problem. Are they going to come back to Michigan and say, oh, wait a minute, now we disagree with that application, you have to apply the full-time, it's part of able and available? Or are they going to say, whatever?
I don't know what
Okay.
the Fed would do for it. I don't know how aggressively, but I do think it would be a misapplication, because our statute in its very language marries the full-time requirement to the ability and availability. And I don't see any reasonable reading of our statute that would separate that.
Okay. And then the last question I would have on this then, if again, and understand, and I will assume that if I were to go ahead and decide differently on that and decide that in fact I could parse out the full time, I will realize I'm doing it with you thinking I'm not being reasonable. I understand that, but it's no problem. I'm messing, right? But my question then would be, do you think it then impossible for us to write a decision that's so narrow that we could not make it clear that in fact this decision, as we were doing this, that we're here's able, here's available, here's full time. Once we have able, once we have available, we're stopping for purposes of PUA only. And this case will only apply to PUA and have no application down the road to anything having to do with a normal application of 21C. That we, if we wrote that decision, wouldn't that be in a sense a stopgap of anybody who came? Not to mention the act itself, it still says now we got to deal with full time for purposes of eligibility. I mean, all we're saying is it's maybe not an ability question, but it's still an eligibility. I mean, if I write the decision that way in such a way that it is absolutely abundantly clear, would you have confidence at least then that claimants wouldn't come down the road with torches and pitchforks and that decision and attacking 281C, the full time requirement?
I don't,
You don't want to give it up. Okay,
that
that's not a
decision.
problem.
I don't know how claimants would treat it. I mean, maybe theoretically there's, some way, but from our perspective, because of the connection between that full-time requirement to ability and availability, I think any case law saying that full-time requirement to those aspects is no longer binding could be used to undermine the ordinary statute in later cases.
Okay.
I mean, we view this as basically a legislative.
I'm good. And I would just hope at this point, Mr. Blanchard, maybe in your rebuttal time that you reserved, maybe you could address that. I kind of asked it to you before, and now you heard the concern, and maybe that's something you could address. But thank you, Assistant Attorney General Smith. Thank you very much for, again, your work and effort. And again, this is, interesting and difficult material. So thank you.
Yes, thank you.
And then last we have Commissioner DePino. Any questions?
Yeah.
We got Runco and Rossi, though.
Oh, yeah, you guys can go next. I'll go first. I do have a question for you, actually. Can you guys hear me? Yes.
Yes.
All right, thank you. So when applying section JJ or section KK, whatever the case may be of the act, are you making distinctions between job functions, like the primary job function versus secondary job function, or are you reviewing the job as the employment as a whole? Does that make sense?
Yeah, and quite honestly, I hadn't considered this, in a lot of detail under KK, just or provisions adopted by the secretary. When I looked at this, I was looking at it predominantly from JJ, as that seemed to be the one that best fit the box people were trying to wedge it in. And I was looking simply at place of employment, and the record regarding Ms. Hollifield's place of employment was that she employed herself and she worked making these deliveries, and she was not an employee of the auction house and didn't necessarily work on site there. And so when I looked at, kind of that language in JJ, she didn't seem to fit that criteria. I think looking at, the primary job functions of a job, it may be a fact-specific inquiry as to, how adaptable that particular provision is, and if there's other business, or if they really are completely shut down by COVID. I think it might be, maybe, I don't know, there's not case law and things interpreting it at this point, but it seems, maybe you could consider additional facts, but we just don't have enough facts to really say with certainty that Ms. Hollifield, or even any, degree of, that burden of proof persuasiveness. I know it doesn't have to be certain, but there is still a certain burden of proof, and it's hard to put Hollifield, to say she met that burden and put her in one of those COVID-19 boxes just based on the record we have.
Okay, thank you.
Mm-hmm. Commissioner Runco?
So I want to just follow up briefly on this JJ type of circumstance where you would have someone that would be eligible because their place of employment has closed. And hey, can you put Rebecca Smith on the screen, because I feel like I'm asking the question to Commissioner Petrick. It says that the place of employment, as you and I saw your brief, you made the argument about her place of employment is actually her self-employment, which I'm going to ask a question about this whole concept of, we keep talking about part-time worker, but this is really a self-employed person, as I understand the circumstance. So I think we've blended things together. But the fact is, in this case, looking at the word direct result, how would you define direct?
I think you need to be able to tie whatever, if we're talking about JJ, their place of employment, I think you need to directly tie in the closure of that business to something immediately following from the COVID-19 pandemic and not some other circumstance. So I think, the most obvious example would be a COVID-19 emergency order shut the business down, like in the case of a restaurant or something of that nature. And so I think you do need to connect something that ties into that wouldn't happen but for the COVID-19 pandemic to that closure.
So when you use but for, I assume then you would say without intervening factors, it would be, without intervening factors or any intermediary, it would just be one, nothing in between, basically. Would that be a safe way to describe?
Yeah, I think you do need some kind of direct tie. Like if you're talking about a business that closed because of economic circumstances, they just had poor business, they weren't closed, but it just, happened anyway and could have happened even outside the pandemic. I don't think that would be a sufficient circumstance.
Well, and the reason I'm asking this is because if we go that direction, no pun, but if we end up deciding this case based on JJ, we're going to have to define what we mean by direct. And so I'm just seeking your input on that, because if it's not an easy term to define in many respects, especially in the context of this case where you do have several factors taking place. So did you want to add anything else to that before I go to my next question?
Yeah, I think just, the use of the term direct instead of, looser language like, some tie to the COVID-19 pandemic, the fact that they use the language direct, I think you do need a somewhat strong relationship between the pandemic and COVID-19 and the closure. And, we just don't have a lot of evidence in this case about the nature of the closure and why the auction house was closed.
So that was one of I know there were a number of issues in this case. The possible infraction against the Americans with Disabilities Act, but the other was this whole concept of harmonizing Michigan law with federal law. And I think you stated earlier, I just want to get this correct so that I don't misstate you and we're on the same plane when I ask the next question, but I think you stated that a state law that stands as an obstacle to the accomplishment of congressional intent, it has to but it has to yield to federal law, correct? Would that be a fair statement?
Correct.
Okay.
Yeah, I think that's pretty clear in case law.
Okay. So then when you look at the CARES Act, so here's some problems I have with this case. I'm just trying to figure it out. So how do we, know what Congress intended? Well, one of the things we do first and foremost is look to the language, obviously. And if you read the CARES Act, 3A, little double I, it says relative to self-certification that the individual has to self-certify they're otherwise able to work and available for work within the meaning of applicable state law, except the individual's unemployed, partially unemployed, or unable to work because of, and that's where JJ comes into effect. So if JJ doesn't apply, then they have to be otherwise available and able to work under state law. But then the second part of that self-certification says the individual also has to self-certify that they're self-employed seeking part-time employment and they do not have sufficient work history otherwise, etc. So Congress right there says that they have to be seeking part-time employment. Now, doesn't that conflict with your argument or doesn't that evince the idea that Congress intended that people seeking part-time employment be eligible to collect PUA?
I think the seeking work inquiry is kind of a different issue than what we're addressing here. We're looking solely at ability and availability. And I think by incorporating state law on the ability and availability without qualifiers, the federal government oversees unemployment. It states in its regulations that states can choose to require people to be able and available for all of or part of a week in question. But they do acknowledge states can choose. People have to be available for all of the week. And some states, Michigan, there is at least one other state that it requires full-time work. I think Congress would have been, in adopting the CARES Act, aware of that and in adopting the state law ability and availability provisions, and the seeking work is a separate inquiry, I think.
So you don't view the word seeking work as an indication that Congress intended that all unemployed part-time workers displaced by COVID should be eligible versus just part-time workers that were available for full-time work?
I think the seeking work is different because somebody can, seek part-time work, but still be available for full-time work. If somebody drops that in their lap, they're different inquiries, and the seeking part is not at issue in this case.
No, I understand that, but I guess the fact is, and I'm not trying to argue, I'm just trying to probe on it. So you're saying that seeking work is different than available for full-time. Seeking part-time work is different than available for full-time work, and maybe actually the act of seeking work is different than of being available for work. I guess what I'm trying to figure out is what Congress intended. So when they intended, did they intend to allow state laws that added an extra? The question is, if Michigan adds an extra bar, so to speak, to the federal act that Congress didn't want in the federal act, then it can't be enforced. But so I guess what you're saying, because they use the word seeking, that doesn't impact the notion of able and available. In Michigan's law of able and available requiring full-time employment is still fine, because this notion that Congress added of seeking part-time employment doesn't tell us that they really intended that part-time workers not be held to seek employment or be available for employment or be able for full-time employment, I guess. So you're carving that out essentially, right?
Yeah, I think we kind of have to, based on the statutory language. If they had intended to make that able and available provision universally part-time and require states with a full-time requirement to impose, a part-time one for purposes of the PUA Act, they could have simply said that a claimant has to be able and available for partial time or part-time. And, states have different requirements. And I think by their blanket incorporation of state law, they intended that ability and availability to mimic whatever the state's law was. And if they had intended otherwise, they could have easily said so.
Okay.
And by including that same kind of part-time language.
And I understand that, and I understand the argument, and I understand your position. And also I want to say, I've been in government for a while and out of government, but I can tell you, it's never easy when you're saying no a lot and you're in a position all the time to have to say no. It's a lot nicer. Right. Yes, here you can have this, so you've got a difficult job. So I guess you don't see the word seeking part-time employment as adding something that would defeat Michigan. Okay. So
I don't think you can read that in.
Okay,
I think we're kind of bound by that text. And if they had intended that, they could have said that, or, not incorporated state law.
Okay. And then the next question I would have is, what about so again, in trying to interpret congressional intent, you've probably seen the reference to the Ways and Means Committee analysis. And I think the Ways and Means Committee analysis directly suggests that part-time workers are eligible. Let's see here. Without any type of requirement that they work full-time. So how would you, do you think that Ways and Means Committee analysis has any impact on congressional intent, or help us determine what congressional intent is in this particular case?
Yeah, I don't think we would disagree that the PUA program was designed to open up benefits to part-time workers, and that part-time workers can claim PUA benefits. The only sticking point is, absent one of those COVID-19 related reasons, they have to comply with state law. And that locks them into having to be able and available for full-time work should it come along. Like I said, I don't think the unemployment agency refutes that basic analysis that part-time workers can be eligible for PUA. It's just to the extent they have to make themselves able and available.
All right. Well, I mean, the Ways and Means Committee analysis uses the terminology history of attachment to the workforce and able and available. There's nothing about full-time work in that analysis, but I'll go on. So Mr. Blanchard made a good point about the UIPL. I believe it's the first one on page 2, and I believe Michigan signed an agreement, right, with the Department of Labor to participate in the PUA program. Did they not? You wouldn't be participating unless you signed some type of an agreement to participate.
I don't know the details of any of that agreement, but yeah, I mean, yeah, Michigan is participating in the PUA program.
So wouldn't you then agree that participation in the program requires you to follow UIPL guidance?
It does require people to, or the states to follow UIPL guidance as a condition of funding.
So if you look at page 2, as Mr. Blanchard suggests, it says when determining the appropriate course of action in administering the program, states should first consult the Act, which we talked about a moment ago. Subsequent operating instructions provided by the department, including UIPL 1620 and 20 change 1. And where the Act and operating instructions are silent, we should look to the DOA. So 1620 change 1 does make reference to a part-time worker who's a student, correct?
It does.
And doesn't that suggest that, and that person could not work full-time, so doesn't that suggest that the intent of this was to encompass part-time workers who could not work full-time?
Well, I mean, that was an example about a student, and there are students who do claim benefits who can make themselves somehow available for full-time work, and certainly those people would be eligible. But I think it needs to be recognized that, you know, the student example, not all states do require full-time like Michigan. And so, you know, maybe it's easier for students in some other states, but Michigan doesn't categorically prohibit students. And so to the extent I think student examples come into play, you know, we're bound by that full-time acknowledgement to the or ability and availability, and to the extent a student can fit within that, they certainly would be eligible in Michigan as they would in other states. And Michigan's UIA's interpretation is not necessarily inconsistent with that DOL guidance.
So you don't see 16.1's reference, I can't remember the question that was the question number, but you don't see that as a directive from the government, federal government, saying part-time individuals who are not seeking full-time work are eligible.
I don't see that as a problem, is because in some states, and that UIPL guidance is given, you know, universally to all states, you know, they're not required to seek part-time or to have full-time ability and availability as they are in Michigan. Under Michigan's unique requirements, students are still able to gain benefits. They just have to meet those eligibility requirements. And under PUA, I think it's notable that, you know, those full-time requirements don't apply if somebody has a COVID circumstance. So if they work for, you know, a restaurant that was completely shut down, or they got sick with COVID, they wouldn't have to comply with those full-time requirements and would fully be open for PUA benefits even without the full-time ability. UIA doesn't dispute that. It's just absent those circumstances, they would need to meet the state law requirement.
Okay, and then I'm winding down here, but you know, I think it's safe to say that there's been a lot of commentary that the PUA was modeled after the DOA, and the DOA, we're supposed to look at the DOA where the PUA is silent. Well, the PUA is silent on this notion of should you be available for full-time work as part of able and available. It does reference state law, but the question is, again, does it conflict? That's what we've been talking about. And if you look at CFR 20 CFR 6045A, it says that addressing availability, states, and this is regarding the DOA, states may, among other things, consider an individual is available for any work at all or a portion of the week claim, whether the individual limits for availability to work which is suitable. So doesn't that tell us that again, that the intent of Congress in passing the Pandemic Unemployment Assistance Act was to encompass and include as many people as possible, including part-time workers who were simply quintessential part-time workers. They work part-time, they don't seek full-time work, they're just out there, you know, working in that category of employment. Doesn't the DOA tell us that?
Well, I think the DUA specific provisions regarding ability and availability, if you look at them, incorporate state law unless two separate circumstances apply, but those circumstances are different than the COVID-19 circumstances. So I don't think the DUA language applies to PUA, at least with regard to ability and availability. With regard to the language that you're quoting about the requirement that people be able and available to work for all or part of the week, I think you really need to parse out and look at that all or part of the week. And by including that all language with the conjunction or, I think the legislative intent was to give states a choice about whether to require claimants to be available for all of the week, as Michigan did with incorporating the full-time provision, or just part of the week, as other states did. If they had intended to make it universal and not give states that choice, they would have simply said that they had to be available for part of the week.
Okay, and I can appreciate your position on that and the agency's position. And I guess the where I want to end up here is so effectively, whether it be a part-time worker or self-employed worker, the agency's position is you have to meet able and available. And part-time workers, self-employed individuals have to certify that they are able and available for full-time work in order to qualify.
Unless they meet one of those COVID-19 specific criteria.
Right. And so, and I guess what happens, see, what's happening is I'm grappling with this. I'm having a difficult time because, the question is whether Congress intended to throw a huge net out there and just grab everybody they could, or whether they intended to throw this huge net out there and just grab some of these categories of people, some of the categories of part-time people, some of the categories of self-employed people. And, I guess that's really what this case is all about. And so your briefing, your argument, and your presentation has been helpful. Thank you very much.
Okay, thank you.
Commissioner Rossi?
Sorry about that. I just had, I think, a question. You said you didn't have the Marvin certifications, right?
I don't have the specific language about, how claimants were asked or when the revision on this was added, or the additional Department of Labor exception was added in.
Do you know, though, without having them in front of you, is there a different set of questions where they customize as a PUA application, the same sort of same questions as regular?
To be honest, I haven't looked at the PUA script. This is the first PUA case I have had that has gotten up on appeal. So I'm not intimately familiar with the specific questions. And I think really at this level, we're looking in determining whether those criteria apply. We're looking more at the ALJ testimony about the facts and the record there.
I also noticed, so at least in the case ending 5736, that's the case that covers weeks from March 22nd through July 27th of 2020. So that first debt as to the 281C issue doesn't come out until October 16th of 2020. So was that determination then issued subsequent to her certifications or subsequent to her benefits payment, or?
Well, her benefits would have been paid for the weeks at issue, the March through July-ish weeks, and then the determination came out after those weeks presumably were paid. I think we're talking about restitution owed for those weeks if she wasn't eligible.
So I guess my question then was going to be, what's the authority for issuing that debt is really like 100 and then maybe 200, depending on the week you're looking at. The debt comes out 100 to 200 days after those weeks were paid.
Well, I think the Michigan Employment Security Act, I think it's section 62, addresses the agency's ability to go back and re-examine issues in a case, and it gives a much longer than a 120-day time frame. So to the extent eligibility issues, come up after the fact, the agency would have sufficient time to address it.
Do you have any more questions, Commissioner Rossi? Okay. Any follow-up from any of the other commissioners? I do have one more question, and I don't want to belabor this, but I'm a little bit loath to go outside of the facts of this particular case, but I do venture outside the facts only because that this is an appellate body that specializes in unemployment compensation cases, and no doubt we will see other cases similar to the Hollyfield cases with respect to the part-time issue. And the question relates to the going to, in simplest terms, from what I see as the unemployment agency's position is that if a claimant fits into one of the COVID-related boxes, that they do not have to certify that they're certify as to full-time work. Is that correct?
That's correct. And that's based in the CARES Act language about that the state law applies except for these enumerated circumstances.
So have claimants who have applied for PUA benefits been required to certify as to a full-time requirement?
You know, I that's kind of outside my purview. Since I don't process claims, I don't know the specifics of what they're being asked when they certify. I presume, if people fit in those boxes, they're being paid even if they're not able and available for full time, but I don't know the logistics on how they're asked about that.
I asked that because this particular claimant, the determination was based solely on the full-time issue, and that she was denied because of the determination that she was not available for full-time work. And I have to assume, based on the certifications, that she was certifying that she had a COVID-related event, and that is what you don't know.
We don't have that in the record. The certifications were not put in the record in this case.
So in terms of our future work, it's the agency's position that if we find in a particular case that there is a COVID-related circumstances, AA through KK, that person does not need to work full-time.
Yes, that's our position, is if a claimant can, firmly put themselves in one of those COVID-19 boxes, the state law ability and availability would not apply.
Okay, thank you. I would, at this point, seeing that there's no other questions, I would go to Attorney Blanchard for any rebuttal.
We'll bring his fees up now.
That's, I have to say, there were times I wanted to jump in throughout the last hour of questioning. It's quite daunting to try and put together a rebuttal of an hour of questions and discussion. But I will try to do so. And I would note I wasn't able to put the camera on because I don't have control over that. I wasn't somewhere else throughout this time. Commissioner Petrick, maybe I can start by going backwards as to your last questioning. I think that really got to the heart of it. The agency's position here today saying that somebody needs to firmly put themselves and prove by some level of either preponderance or clear and convincing evidence that they fall within one of the PUA categories is not true, is not the law, and violates the directives of the Department of Labor. If you look at UIPL 16-20 change 5, it is quite clear what the requirements are and what the state is to do in applying the PUA benefit. If you look at the CARES Act itself, Section 3, Section 2102, subparagraph 3 defines a covered individual, and there are two requirements to be a covered individual. You have to be not eligible for regular benefits, and you have to self-certify that you fall within one of those categories. Those are the two requirements for PUA. Providing a self-certification in change 5 is clear that it should be an easy checklist for people. It's fine to remind them, and in fact required to remind them, that they have to be truthful and required under law to be truthful in those certifications. But there is no right to have a further evidentiary hearing or for the state to question that without, some evidence of a false statement. That is directly contradictory to what the Department of Labor has told the states in administering this program. There are two prongs to the requirement, subsection 3A, subparagraph I and II, Romanettes, I guess you call them. You have to be not eligible for regular benefits, and you provide a self-certification that you fall within one of the covered categories. To Commissioner Rossi's questioning about what happened here and how this played out, yes, I know from personal experience, again, it's not a matter of factual record, there were essentially no PUA kind of qualifying questions at the start of the pandemic in April when it began to be applied and considered. Over time, the certifications developed more PUA specific questions, but not precise and not applying the self-certification criteria that the Department of Labor has now said is the way that you need to apply that. The claimant and no PUA claimant for the time period, at least through June, was ever asked about full-time work. And beginning in the fall, there were both certifications changed about full-time work, and the agency began issuing, the fall of 2020, the agency began issuing eligibility review questionnaires. And those questionnaires asked if you were unable to work full-time because of a childcare responsibility, unable to work full-time because of a medical condition, etc. And many people, many Michiganders wrongfully got denied and shut off of the PUA program because of those questions that were completely inconsistent. I don't know if that's what happened here. I do know that the questions evolved over time, and Ms. Hollyfield, like many others, after collecting benefits under the federal program that was applied, was disqualified, issued these one determination on ability first, after she had collected the benefits and sent a $10,000 bill based on questions that weren't asked when she applied for benefits or certified for benefits. And that is a serious problem, and it's a serious problem if we've got 7 commissioners here that can't figure out what full-time means, and you expect the people of Michigan to figure it out on their own. And I'll get back a little bit to the meaning of full-time. I do want to really address that discussion. But that's a serious problem in the administration of the unemployment system. And people should not be getting $10,000, $20,000, $30,000 bills for reconsiderations of the agency. In Ms. Hollifield's case, she protested the ability, she got an ability determination, never anything about whether she had self-certified or whether she fell in one of the pandemic unemployment assistance categories. She got the ability determination that said because you're not able to work full-time, you don't qualify. She protested that. In response, the agency called her and the agent asked her, are you able to work full-time and available to work full-time? And she said, no. I explained that in the protest, to paraphrase. And so they issued a second determination saying that you're unavailable, and the one that Commissioner Rossi referred to, as well as issuing a redetermination saying we still believe you're not able also. But it's very telling that the agency itself has separated out able and available, and there are other categories. Full-time is not part of a definition of able. It's not part of a definition of available under the statute, and I disagree strongly with the agency's position on that. If you want to look to the actual language of Section 28(1)(c), it says that the individual is able and available to appear at a location of the unemployment agency's choosing for evaluation of eligibility for benefits if required, and to perform suitable full-time work of a character that the individual is qualified to perform by past experience or training. And it goes on, and we could parse, there's another reference to full-time later on, and we could parse that out. But I think it's very clear from the statute that full-time is a separate requirement under Section 1C, and it's an eligibility requirement. What does full-time mean? That's another question that I'd like to address, and maybe I can address more in in the questioning here. The second reference to full-time within section 28(1)(c) has full-time in a clause, and it says, talk about suitable work, which is of a character generally similar to work for which the individual has previously received wages and for which the individual is available, comma, full-time, comma. Full-time is inserted as an independent clause, is not part of the definition of available. And then it goes on, either at a locality at which the individual earned wages, et cetera. And Commissioner Young kind of notes that and how that can be parsed. But there's clearly nowhere in the statute in which it says ability is defined as being able to work full-time or availability is being able to work full-time. What the statute does say in section 28, and the only place where it does arguably define availability is where it enumerates categories where people are deemed to be unavailable. Again, none of those say people that can't work full-time are unavailable. There's no reference to any of those arguable exceptions to availability that are enumerated. So it is an eligibility requirement, and it is not part of able and available. But to Commissioner Ozarski's questioning and point, I think it's a very important point. It's full-time is not defined in the Act. It's heretofore not done a lot of work in the questioning and the determinations here, because usually under regular benefits, you will find people that have to have base period wages and sufficient something that would be considered under some definition of full-time work. Where I think I both agree and differ from the Attorney Smith's position and the agency's position here. There's some discussion of what full-time means. In one reference, and there are two different things. In one reference, we heard from the agency that full-time is kind of self-defined. If the person can say they work full-time, then that satisfies it. If they say they can only work part-time, then they're opting themselves out from that criteria. I think that is a very dangerous precedent. I don't think that is correct, and I differ from that, although it might be useful to claimants in some ways to just self-define or self-certify that criteria. Where I do agree with the agency is that full-time is defined in the Act, to the extent it means anything at all, is defined with reference to the kind of work that the individual under Section 28
Appears Mr. Blanchard may be frozen up. We'll see. Mr. Blanchard, if I can interrupt for just a moment, your screen is freezing a little bit. My suggestion is if you have any applications or programs that you do not need, you may want to shut those down. They could be contributing to the problem.
Oh, I'm so sorry.
Or if you have anyone in your office or household that may be using bandwidth, you might want to contact them and tell them to suspend their activities for the moment.
There's a Zoom mediation going on in another office here. So,
okay, well, you're back now. I guess go ahead and continue.
I'm sorry, I don't know where I lost you, but I was saying I agree with the agency that full-time is really understood as a reference back to the type and character of work that the individual had usually and previously engaged in. And so for this purpose, I would say that the full-time work is like Commissioner Ozarski suggests out of the Bowles case, is really just defining the attachment to the workforce in that way. You would expect somebody who lost their employment to be able to work that type of work, and that's a connection to the workforce. I think that's the real work that the statute does there, and that's all it was intended to do by my analysis, because there was never any attempt to define what full-time means. to say that the legislature defined attachment to the workforce as full-time is not quite correct and would not be correct. There are numerous places within the UIPLs and otherwise that reference attachment to the workforce and make clear that it's not attachment to the workforce, which is it's a standard under federal law for the program, both the DUA, PUA, and general benefits, regular benefits, I should say. Attachment to the workforce is separate and distinct from full-time, and nowhere in the act has the legislature ever said that we define attachment to the workforce in that way. If my feed fails at any time, I hope somebody will just speak up and tell me if it's not coming through well. To Commissioner Young's point, what will the Fed say if the commission reads Michigan's able and available standards not to include full-time, as do most states? The Feds will say, and that's reflected in the UIPLs, and I think I quote the UIPL 10-20, the Feds will say that particularly that the states have flexibility in applying their standards and that the states need to meet the DUA definition of 604.5, 20 CFR 604.5. That's been a clear directive from the Department of Labor. And so all we're asking is that the state, like the vast majority, 48 out of 50 states, come in line with providing benefits to the swath of people that were intended to be covered under the PUA Act and not apply a separate and distinct full-time standard. The talk of the individual either having to fall within one of the enumerated categories of the CARES Act or having to, the part-time or self-employed individual having to fall within one of those categories or having to satisfy the full-time able and available standard does not the application of the CARES Act. There's no other category other than the covered individuals that fall within the section 2102 subsection 3. There is no other category. And so I don't understand what the state agency is suggesting when they say that. But I do understand what we've heard quite clearly from the state is that when somebody falls into one of those categories, AA through KK or beyond, because the Department of Labor can add some, and they self-certify to that, then and only then are they eligible for the PUA program. And then and only then they should not be subject, and the state has admitted they would not be subject to a full-time able and available standard under state law.
Excuse me, Attorney Blanchard.
Yeah.
You cut out there for a moment, and I was distracted by me trying to get back in, and I didn't quite understand and comprehend your position with respect to the agency's position that you don't have to certify for full-time employment if you get into one of the COVID boxes. Could you tell me what your position is on that?
I agree with I think I agree with, if I understand your question, with the agency's position. If you're a covered individual, to be a covered individual under the CARES Act, you have to fall within one of the enumerated categories as defined or expanded by the Department of Labor. And only then are you a covered individual that's eligible for PUA benefits. And what we've heard, as I understand it from the state, is if you fall within one of those categories, then the state's able and available and full-time requirements would not be applied. If I understand that correctly, we are in agreement with that. And the only thing that I'm pointing out here is that there is no separate category of people that get PUA benefits that don't qualify under one of those categories.
Okay, thank you.
I think that's a very dangerous position that the agency is inviting you to consider and take evidence and apply an evidentiary burden standard regarding qualifying for one of the PUA criteria. I don't think that's the law. It's not the law. And furthermore, there's no basis to do so. The issue is not ripe in this case. There's no jurisdiction to decide an issue that's never been subject to an adverse determination by the agency or an ALJ. And, you know, beyond that, the commission has an ability, as the agency has noted, to take evidence and to admit evidence. It has not done so in this case. There has been no application to submit evidence, no invitation to submit evidence. So to take the hypothetical evidence, which I think the agency is asserting that looking at the record, he now doesn't think that there's enough evidence submitted and there's a lack of other evidence that the agency might want in order to qualify somebody under one of these categories is not an analysis of the evidence itself. Pointing out a lack of evidence or objecting to the record below is not an evidentiary hearing, is not one that the commission should engage in at this time. The claimant applied for PUA benefits and was granted PUA benefits and found to be qualified for those benefits. I discussed, I think, MyWAM certification. Certainly through at least early July, there was no question of whether somebody could work full time. And it's a very dangerous question, especially as I started out by saying, if we've got smart people around the table here, they can't agree amongst ourselves what it means to go asking an unemployed single mom that lost her part-time work if she can work full-time, if we can't even figure this out. And that's exactly what's going on here. There are students, if you're a college student and you're asked if you can work full-time, how you answer that there's a lot of processes that go on there. Do you mean, in a regular week? Do you mean in the summer? Do you mean, do you mean any hypothetical work? As the agency seems to argue now, based on the Ross case, that somebody should be able to testify they could do any kind of hypothetical full-time work and therefore qualify under the statute. I don't think that's the standard exactly either. I don't think that's what Section 28 says. But if that's the standard, then everybody could meet that. If you could just testify that you could, if it were a sleep study full-time, that you just had to lay in bed at night, you could probably make a full-time job of it. I don't think that's the standard. I think that's, and it's absurd, frankly, to impute that on everyday Michiganders, that they would know how to answer that question or know that they should testify that they're able to work some hypothetical job. If you're a mom who has full-time caregiver responsibilities and lost your part-time work during this pandemic, when asked that question, the layperson's response is going to be, I can't work full-time. But you could theoretically work at night. You could theoretically work from home and cobble together 40 hours. But that's
Attorney
not how
Blanchard?
I would interpret it. Yeah.
You've come to the end of your rebuttal period. So if you want to make one or two more statements, I'll have you wrap it up.
Okay, thank you. I really don't have much more to say except that you should interpret the statute and interpret the application of PUA in a way that works for everyday Michiganders with standards that are understandable and applicable for them and without a shifting standard that evolves over time and leaves people with bills for tens, $20,000, $30,000. That would be good. That would be a better system.
Thank you for your presentation.
Thank you.
AAG Smith, I'm not certain, did you reserve time for rebuttal?
Specifically reserved. I do know I have time. I didn't use the full 20 minutes. Can I just make a couple
You may.
comments?
Go for it.
Okay. I just want to keep this focused on the statutory language. Section 28(1)(c) requires an individual be able and available to appear if required and to perform suitable full-time work. I'm looking right at the statute. The full-time language is right there in that statute. You can't read that out. And then the CARES Act, in turn, looking specifically at the statute, requires claimants to be otherwise able and available for work within the meaning of applicable state law. It specifically incorporates the state law ability and availability requirements. So we're bound by those full-time circumstances except where one of those COVID-19 circumstances apply. So if somebody can establish or, apply those COVID-19 circumstances, by all means, but otherwise you are bound by that full-time language. I would agree with opposing counsel's statement that the UIPLs do give states some flexibility in terms of these issues, but they don't allow states to ignore their own state law. And Michigan's legislature felt that a full-time attachment to the labor market was required, and the federal regulations requiring states to enact ability and availability requirements allow them to do that by saying that states can, incorporate provisions that claimants be available for all or part of the week. And Michigan's legislature believed that it decided to follow that all option in adopting the full-time requirement. And so we're bound by that in the absence of one of those COVID-19 circumstances, and the statutory language. Any other reasonable interpretation just simply doesn't, look at the words of the statute. While sympathetic to Hollifield and others in her position, there's simply no way to wedge her circumstances into that statutory language. This said, lots of other part-time workers can and do claim PUA benefits. And so the state's not trying to categorically strike out all part-time workers or anything. I just want to make that clear for the record. And so I'll rest with that. But the focus should be on the statutory language, and it does, block in those full-time ability and availability requirements in the absence of a COVID-19 circumstance.
Thank you very much. This has been a really valuable and educational discussion, and I really appreciate the input from the parties. And additionally, I note one more time, we appreciate the amicus briefs that were filed as well, and we will be reviewing the issue and having a full commission decision following discussion on the matter. So thank you again for appearing before us today.
Thank you.
And with that, we'll close it out. Have a good afternoon, everybody.